There are multiple types of easements, or non-possessory property interests, that allow the holder to use another's land. Easements by necessity arise if a landowner severs his or her land into two parcels, conveying one and retaining the other, and an easement is necessary across one parcel to allow for the use and enjoyment of the other. The easement can benefit the original landowner or the purchaser, depending on which land parcel needs the easement. In Strollo v. Iannantuoni, we explore the scope of an easement by necessity. Roger Strollo's property was landlocked. The only way to access the road was to cross adjoining land owned by Maria Iannantuoni. Strollo filed a suit against Iannantuoni, seeking legal recognition of an easement by necessity across Iannantuoni's property. Iannantuoni didn't contest the easement itself, agreeing that the requirements for imposing an easement by necessity were satisfied, but she contested the scope of the easement sought. At trial, it became clear that although Strollo's land had historically been used for agricultural purposes, consistent with zoning regulations, he desired to put a housing subdivision on the property. That plan would have required an easement 50 feet wide. Iannantuoni argued that the easement should be limited to use for farming and recreational activities on Strollo's property, the property's historic and current use, and that an easement 20 feet wide was sufficient for that purpose. The trial court agreed with Iannantuoni, recognizing an easement by necessity 20 feet wide and limited to use for farming and recreational activities. Strollo appealed to the Connecticut Appellate Court.